May I proceed?
Certainly may.
Good afternoon.
Good afternoon.
Can you please state your name and spell your last for the record?
My name is Jermaine Darnell Lorian. My last name is spelled L-O-R-E-A-N.
What do you do for a living, Mr. Lorian?
Well, for the past 5 years, I've been the chief auditor at my own firm, Greylord Strategies Incorporated. We consult with police forces at the federal, state, and local level to discuss proper police protocol and techniques and strategies as well.
What education do you have that allows you to hold that position?
Well, I have my bachelor's degree from Virginia Commonwealth University. I have my Juris Doctorate from Johns Hopkins University, and I also have my master's in law from Harvard.
What experience do you have in your field?
Well, after I obtained my master's, I went to work for the White Collar Crime Division at the FBI for 25 years. I was a part of numerous undercover operations concerning robbery, human trafficking, tech crimes, you name it, I was there.
What qualifications do you have in your field?
Well, I'm licensed to practice in Virginia, Washington, D.C., as well as Maryland.
Mr. Lorian, how are you involved in today's case?
Well, I was retained by the defense for 2 reasons. To investigate the protocol of the Midland State Police Department regarding the arrest of Avery Bancroft, as well as the undercover protocol Mickey Keenan used.
To provide your opinion on the practices in the MSPD, did you use sufficient facts and data?
Yes.
And what were those facts and data?
Well, I consulted Greylord Strategies to see if the protocol that Mickey Keenan used lined up with the proper ones.
In analyzing the procedures of the department, did you use reliable principles and methods?
Yes.
And what were those principles and methods?
Well, I used very commonly used techniques in the field for detecting deception, anything fraudulent going on within the case.
Were the principles and methods that you used reliably to the facts and data of today's case?
Yes.
And how did you begin your investigation, Mr. Lorian?
Well, I began using the Greylord Strategies to see where the Midland State Police Department's investigation lined up with the proper ones, like I stated before.
And how did undercover investigation play a role in today's case?
Well, in the white collar world, a lot of crimes involve undercover work because they involve 2 people that are willing participants. They're consensual. In today's case, we're investigating bribery, and Mickey Keenan was the undercover officer who was set up to carry this task out.
In your expert opinion, do undercover agents receive special training on how to properly implement undercover guidelines?
Yes, whatever agency the undercover agent is working for should properly maintain the proper techniques and trainings for all their agents. If an agent does not know any of the protocol or all of the protocol, the investigation is not supposed to take place.
And why is that so important?
Well, it's important because anytime you have an agent who doesn't know the proper protocol, isn't carrying out the correct task, or isn't documenting everything that's going on, the investigation is null and void.
What did you find in regards to Mickey Keenan?
Well, we actually found that Mickey Keenan had violated every single rule regarding the proper undercover protocol.
Objection, Your Honor, that's an improper opinion. Opposing counsel has laid no foundation into what specific principles and methods were used by this witness. They solely asked if they were used and then described a couple general principles. He did not state whether or not these have a known error rate, as is necessary under case law Davis v. Adams. Now, under the Midlands Rules of Evidence, trial judges must ensure that any scientific testimony and evidence admitted is not only relevant, but reliable. Determining whether expert testimony is sufficiently reliable, judges should consider not only the methods employed and the data relied upon, but also, they should consider only the methods employed and the data relied upon, not the conclusions themselves. The proponent of the evidence has the burden of proving each section of Rule 702 by preponderance of the evidence. Opposing counsel has laid no foundation to precisely what the principles and methods were used in this case.
Do they need to do that for me to find that the witness has been properly qualified?
Yes, Your Honor. Opposing counsel under Rule 702 needs to lay out that this witness used reliable principles and methods and explain. We have to look at those principles and methods in order to determine whether or not the conclusions are reliable under Rule 702. Opposing counsel did not lay that foundation. They simply said, yes, we did have reliable principles and methods, did not elaborate them, did not go into any known error rate for them.
Counselor, do you have a response?
May I reiterate and delve more into the principles and methods, Your Honor?
If you feel that you need to, yes. Your objection will be sustained, and you can lay the foundation you feel is necessary.
Yes, Your Honor.
Yes, Your Honor.
What were the principles and methods that you used in your analysis?
Well, there are a number of them that we actually used. There is, I don't know which one to start with. I guess I'll start with the ACE-V. The ACE-V is used to detect anything that could possibly be deceptive, anything that could possibly be fraudulent, any possible people that we don't know that are coming in, anything that is not a part of the investigation, anything that hasn't been properly laid out in guidelines, anything that hasn't been properly documented.
Objection, Your Honor, is to improper opinion of this witness's use of the ACE-V test. If I may make an offer of proof.
Sure.
This witness states nothing about an ACE-V test in his expert report. And I'd actually like permission to voir dire the witness
You really want to voir dire the witness?
on the use of this ACE-V test.
You may attempt to voir dire the witness.
Yes, Your Honor.
Counselor, you should retake your seat. Once the voir dire is complete, you'll be allowed to continue your direct examination questioning.
Yes, Your Honor.
Mr. Lauren, I'd like to ask you a little about the principles and methods you use. Now, in direct examination, you just stated that you used something called the ACE-V test to come to your conclusions in today's case.
Yes, that is true.
Now, you remember preparing an expert report in today's case, right?
Yes, I do.
You recognize if I showed it to you in court
Of
today?
course I would.
May the record reflect that I'm approaching opposing counsel and the witness in turn with the audit report of J.D. Lauren. May the record reflect, or actually, may I approach the
Yes, you can.
witness? Mr. Lauren, I've just handed you your expert audit report, correct?
Yes, sir.
It bears your name and Great Word Strategies at the top,
Yes.
and you told the truth in this report, correct?
Yes.
Now, in this report, you talked a lot about your qualifications and also the methods that you used. I'd actually like to direct your attention to some of those used. Now, if you could direct your attention to page 4. You discussed the relevant conclusions from the 2014 audit of the MSPD's undercover investigations, correct?
Yes.
Now, you described in this page 4, something called the undercover guidelines, right?
Yes.
Now, on direct examination, you said you used something called the ACE-V test, right?
Yes, sir.
However, the ACE-V test is present nowhere in your expert report, is it?
No, I guess they must have left it out.
But you knew that you were told to include all relevant evidence in this report, right?
Yes.
You had up until today's trial in order to update this with relevant information.
Yes.
So what you're telling this jury is that you failed to include relevant information in this report,
Yes, I did.
and that you based your conclusions on information you didn't even include in your report. May I approach the witness and retrieve?
You sure can.
Your Honor, at this time, I'd like to re-raise my objection to improper opinion. This witness has not elaborated on the known error rate of the ASB test. He failed to include it in his expert report, and therefore, all of his expert conclusion that Mickey Keenan failed to follow the undercover operations is an improper opinion, and it's inadmissible in court today.
Counselor, do you have a response?
Yes, Your Honor. There has been, Your Honor, I would ask that we can lay proper foundation on the other principles and methods that was used by the expert witness.
Are there other principles and methods that he used to come to his conclusion?
Yes, Your Honor.
Then let's hear what those are.
Yes, Your Honor.
Yes, please.
Mr. Warren, you use many principles and methods while coming to your conclusion, correct?
Yes.
And can you remember all of them at the moment in time?
Not all of them at the moment in time, no.
Would you like a reminder to help jog your memory?
That would be phenomenal, yes, sir.
Let the record reflect that I'm approaching the witness.
Can I see that document before you call the witness?
Let the record reflect that I'm approaching the witness.
That's fine.
That's, okay, that's just too much.
May I direct your attention to page 6? Your permission to confer with co-counsel?
Yes.
Thank you, Your Honor. Mr. Logan,
Sir.
I'll ask you again, what were the principles and methods that you used to reach your conclusion?
Well, counsel, I simply, I can't remember, counsel.
Let the record reflect that I'm approaching the witness.
Would you like to have the witness read anything out of that document? Or would you like to try and enter it into evidence and have the witness tell us about it? If you're using it to refresh the witness's memory, you can direct him to specific portions.
Mr. Logan, I would like to direct your attention to page number page number 3. 3.8. Here you say that you examine the MSPD.
Objection, Your Honor, this is a leading question from the from the expert report. If he wants the witness to read from the report, he can do, opposing counsel can do that. However, opposing counsel cannot testify under the record on direct examination.
You're right. Just ask him to read what you want him to read.
Yes, Your Honor. Can you read, please read number 3.8.
At the request of the defense counsel.
Objection, Your Honor, to hearsay.
Overruled.
At the request of the defense counsel, I also examined MSPD's procedures for evidence collection, interrogation, and officer training in this case. The information provided to me, either via public records request, Gray Lord's prior audit, or defense counsel, was sufficient to offer an opinion related to this case in particular. However, my opinion should not be taken as an audit or assessment of MSPD's practices in these areas as a whole.
I would also like to direct your attention to page number 2, 2.4. Can you please read 2.4 for me?
I have written 15 law review articles. This research has involved white-collar crimes, defenses to white-collar crimes, and Fourth Amendment jurisprudence. 5 of my published articles focus specifically on entrapment, the character traits of informants, and their predisposition for criminal behavior, and the importance of protecting informants from inducement. With 2 colleagues who are forensic psychologists, I have brought my experience on police procedure to bear the knowledge of social psychology to publish 2 peer-reviewed articles on cognitive biases and forensic testing.
Can I please also direct you to page 3 again, 3.6, and may you please read that?
I requested an interview with Chief Francis Kimball at MSPD in order to update my 2014 audit findings of MSPD's current practices. I assumed that they had implemented our recommendations as promised and were in strict compliance with the audit. Our request was denied. Therefore, for the purposes of this report, I assume that MSPD's new administrative guidelines for undercover operations were in strict compliance with the recommendations in the 2014 audit, and therefore in strict compliance with the Attorney General's guidelines for undercover operations.
Now may I direct your attention to page 5, 4.2.1.
Authority level and approval processes are prescribed in the undercover guidelines based on the type of undercover operation proposed. Undercover operations are classified in 2 different group categories, Group 1 and Group 2.
Can you please read 4.2.2?
Group 1 UCO must be approved by the highest level of authority.
This time I'd object to hearsay, as these statements are not going towards the witnesses. No longer is opposing counsel reminding the witness of his credentials or his principles and methods. He's now going into the conclusions of what the undercover operations state and going into Group 1 UCO. Therefore, Your Honor, reading this portion of the document is hearsay and is inadmissible.
Counsel, can we just hear what his specific methods that he used were, and then you can ask him without the aid of the document what his conclusions were?
Yes, Your Honor.
Let's do that.
Move to strike, Your Honor.
Whatever testimony was elicited will be stricken.
Yes, Your Honor.
May I direct your attention to page 3.
All the documents I received about the current bribery charges were collected via public records requested with the Midland State Police Department.
I'd like to object again, Your Honor. At this time, this is talking about evidence, not the principles and methods of this witness.
Counsel, I just want to hear about how he analyzed the information that we had. The witness told us what facts he had, the documents that he had. All that we need to hear and have his memory refresh on is how he applied what he does as an expert witness to those facts. Once we have that down, then you can take that away and he can talk from his own recollection about all of his conclusions, everything else.
Yes, Your Honor.
Yes, Your Honor.
Mr. Loring, can I direct your attention to page 1? 1.4.
This report contains all of my conclusions associated with this case. I understand the rules of criminal procedure and further understand that this report will be provided to both parties in preparation for trial.
I'm gonna save us all a lot of time here. I think that he was properly qualified the first time that you did it by simply saying that he had reliable principles and methods. He applied them to the facts. So take that away and have him talk about his conclusions.
Yes, Your Honor.
Yes, Your Honor.
Mr. Logan,
Yes, sir.
what did you find in regards to entrapment in this trial?
Well, in regards to entrapment, we found that Mickey Keenan used entrapment. We found that he did not follow any of the proper protocol when regarding being undercover. We found that he used very coercive techniques and the way he handled the undercover operation.
How did predisposition play a role in your investigation?
Well, we found that Mickey Keenan was a pretty aggressive cop to begin with. We found that
Objection, Your Honor, lack of personal knowledge. The state has a good faith belief that this witness has never met Mickey Keenan, has no idea about his personality, and to say that he was aggressive is speculating into his mindset, speculating into the things he did, how he acted. And therefore, it's both speculation and the lack of personal knowledge.
Do you have a response, Counselor?
Yes, Your Honor. Mr. Loyan has read Keenan's affidavit, and he has assessed it to a high degree. And this would allow him to come to a conclusion on Mickey Keenan's behavior.
Is he offering his conclusion as an expert witness?
Not this one, no. This is helping him come to his conclusion, Your Honor.
Okay. Counsel?
Your Honor, if it's not being offered as an expert testimony, and this witness has no qualifications to go into the mindset of Mickey Keenan or talk about personalities, then there's no foundation, and it's speculation for this witness to go into Mickey Keenan being aggressive, Mickey Keenan being an aggressive person, Mickey Keenan acting aggressively, and there's no foundation laid that this witness has met Mickey Keenan, analyzed his procedures, analyzed his tactics. Therefore, Your Honor, this testimony is inadmissible.
Counselor, has there been foundation laid that he had access to all the witnesses' affidavits who all had interactions with Mickey Keenan?
To the affidavit, yes, but that's the limits of this witness's knowledge.
And can an expert witness also give lay testimony?
They may, Your Honor.
Then your objection will be overruled. Please continue.
Yes, Your Honor. And how does predisposition play a role in your investigation?
Well, based on the affidavit of Mickey Keenan, I found that he was pretty aggressive in the way that he went about the investigation. Again, he used really coercive techniques, and which made it more likely for him to go off of the script.
And did you come to a conclusion in your analysis?
Yes.
And what was that conclusion?
That Mickey Keenan did not follow protocol for the undercover operation.
Thank you, Mr. Loyan. I have no further questions.
Thank you, counsel. Cross-examination?
Yes, Your Honor.